elected members who are elected by the people.
Chalo guys.
Parliament consists of elected members. These are the members who are elected by the people. So whenever such a law is challenged before the court will presume the law is constitutional. It is for the petitioner to prove that the law is unconstitutional. Why? Because the assumption is that this law, since it has been passed by the Parliament consists of elected representatives. These representatives are elected by the people. This law will be applicable on the people. Why would these elected representatives make a law which is against the people? No. So we will presume that the law is constitutional. That's what we call presumption of constitution. That's why when this year Waqf law was challenged before the court, and it was argued that this law be stayed. Stay should be imposed on this law. The Supreme Court invoked this doctrine of presumption of constitutionality, saying we will presume that the law is constitutional. It is for the petitioner to prove that the law is unconstitutional. That's presumption of constitutionality. You can view it in similar case. In a sense, in criminal cases, the burden of proof is on the prosecutor. If you're accused of terrorism or you're accused of murder, you don't have to prove that you are innocent. The prosecution has to prove before the court that you are guilty, and to beyond any reasonable doubt. Even if there is a slightest doubt in the mind of the judiciary that you may or may not have committed this crime, you will be acquitted. Because the person who has to prove that you have committed this crime, the higher burden is on that. Similarly, when a law is challenged before the court, courts will assume that since this law is enacted by the legislature consists of elected members of the public, and as such this law is presumed to be the constitution. It's for the petitioner to prove that the law is otherwise. But what about rules? Rules are made by executive. For example, last year we saw fact check unit. Rules were made under the IT Act by the executive. These rules were stayed by the Bombay High Court. Why? Because for rules, presumption of constitutionality does not apply. Because executive is not directly elected by the public. Legislators are directly elected by the public. The courts will assume that if there is a rule made by the executive who are not directly elected by the people, they may make rules which are against the public. But legislators, they may not make laws which are against the public because public elects them. Long story short, presumption of constitutionality applies only to laws enacted by the legislature, not for rules made by the executive. Presumption of constitutionality. Fifth one, doctrine of tolerable legislation. For that, I'll discuss an important case, 80 Mupil Nair, the state of Kerala, 1961. We're talking about 1961. And in 1961, right to property was still a fundamental right. Because right to property was deleted as a fundamental right only by the 44th Constitutional Amendment Act 1978. Why was it removed as a fundamental right? You let me know in the comment section. Let me give you an assignment as well. You tell me in the comment section why was right to property deleted as a fundamental right. But be that as it may, in 80 Mupil Nair v. State of Kerala, 1961, and remember this period, right to property is still a fundamental. The petitioner had 25,000 acres of land which was considered to be the farmland, or which was considered to be the forest land, or which was considered to be the government land. And on that, 2 rupees per acre was some sort of a tax imposed on this land, which means this individual had to pay 50,000 as tax. right or wrong? But this individual, despite the fact that he was in possession of 25,000 acres of land, he could only get the revenue from this land, which was worth 3,100 rupees. Why? Because majority of this land was barren. Majority of this land was not productive land. Majority of this land was not put to productive use.
चलो गाइस एंड करते हैं.